Is it time to lawyer up? I guess it depends on what you think. I interviewed a prospective client today that has a small child. This person was part of a relationship, resulted in the birth of a beautiful small child. The child is months old, and the relationship fell apart. Now, they had worked out, parents had worked out an agreement, a verbal agreement that encompassed support and periods of parenting time. And it was never reduced to writing. The breakup it's a fresh breakup. The person that is not my client or my prospective client obtained an attorney first. And the verbal agreement was modified, or how should I say this? The verbal agreement has been in place for a few months. Child's only months old. The other person secured the services of an attorney, and the prospective client received a suggested offer. The suggested offer materially changes the agreement that the parties have been operating with. So say the visitation was going to be Tuesday through Thursday, and then every other weekend, or Friday till Monday. It cut the time in half. So is that nice? It's not nice. The support that was being paid, a higher amount has been requested. That may or may not be appropriate. What else? The pickup and drop-off location was changed, right? So certain terms were changed. Now, to what end? I don't know. I don't know if when I get hired, I understand that'll be soon. When I get hired, I have to look at, I'm going to take you through the steps that I'm going to take along with the client. What was the arrangement that they were working on for this short period of time? What is the proposal? So let's look at that first pattern in practice. And then what is being offered? Is it outside the realm of normal? Is it outside what's typical? Does it curtail my client's period of parenting time to such a significant degree that we can't agree? Sure, in any agreement, there might be, let's meet in the middle. Let's have, let's see which points and which circumstances are more important to us, which are more important to the other side, and see if there's give and take, and to see what is offered and compare that to what perhaps a standard template is, or a rather typical approach, splitting holidays or sharing holidays that are more important for one side's family as opposed to the other side's family, and then compare what's offered, not only in relation to what a typical arrangement might be, but compare that to what the parties had sort of worked out. Now, you have to figure that the other side went to an attorney first because they were not satisfied with that arrangement and the agreement and didn't want to keep with it. So you have to take all those factors into place. Now, these individuals were not married. How do we address that? Well, we can make an agreement, and that's an agreement to agree, or we can take it to court. So the family court is for persons that share children, and you could be married or unmarried, but that is the location that you would have custody and visitation matters and support matters for persons that are not married, right? So if you're married, you can go to either the family court or the Supreme Court for those areas, for that type of agreement. And additionally, if you're married you can go exclusively to the family, not family court, to the Supreme Court, because that's where you get divorced. So, well, those are some of the issues. That's how I analyze a case. That's how I speak to my client about it. And we always prepare, and I don't want to say this, I do want to say it, anticipate going to court and having to face a trial, but we don't seek it out. So we prepare right from the beginning, and we are trial attorneys in the office. We've had thousands and thousands of days on trial in the family court, in the Supreme Court. So we prepare for trial. Direct, cross, what we can prove, what we can, how we can refute. So we're always prepared, but we're equally ready to settle, right? So settlement when possible and trial when necessary. That's the catchphrase.